All righty, we're going to go ahead and get started. Good afternoon, everyone. I know some people are still joining, but we're going to go ahead and get started. I just wanted to welcome everybody first to our latest fireside chat in the series of webinars we've been putting on. We're happy to be able to bring this series of informational chats to all of you to help through the challenging times we're obviously all experiencing. I'm Frank Niesenbaum, VP of Sales for C2B Tech, and I'll be your host today. I'm also very excited to be joined by Tom Herron, who is a partner with the prestigious law firm Franz Ward. Tom is going to bring some of his extensive legal experience in and around the cannabis industry and help us understand a little bit about the legalities and legislation for and around the cannabis industry, hopefully to help your businesses, those of you attending, navigate through all these uncertain times, as well as come out on the other side a little stronger than you went into it. As usual, we hope everybody enjoys the wonderful warmth of the fireplaces behind us. Kind of hokey, but we think it's kind of cute to show everybody that we're just trying to keep this comfortable and light, get good information to everybody in these challenging times. And those of you that are still doing business and hopefully be able to value the information as you get back to normalcy somewhere down the line. So again, welcome, Tom. How are you?
Well, Frank, thanks for having me.
Great. Today we're going to talk, as we said, a little bit about the legality information in the cannabis industry. To start, I know not everybody's on there. We'll give it the poll a minute or two. We just want to get a sense for people and see how, if you're open for business, just trying to get an idea if you're fully operational still, maybe with some modification, or no, you're kind of sitting back, kind of waiting for all this to shake out. So take a minute or so to answer the question, and then we'll get started with letting Tom give us some good updates and good information. Okay. That looks like everybody that was on is on so far. I'm sure there'll be some others later, but it looks like, based on what I'm seeing, it's kind of what we thought, what we've been thinking, that especially around the cannabis industry, most people are operational, I think, in some capacity. So Tom, my first question is, how's the whole pandemic affecting you and the firm? You guys struggling through, getting by?
So from an operational standpoint, really the biggest change is that the majority of our lawyers and staff are all working remotely for the last few.
I think we froze there for a minute. Oh. I think you're frozen, Tom. Hopefully it'll come back quick.
So I'm doing most of my work electronically. A lot of my clients are not located in Cleveland, so they're either in different states or at different parts of the state of Ohio. So a lot of my practice is done by email and telephone anyway. Yeah. So for me, the biggest change has just been that I've been home for the last 4.5 weeks.
Yeah.
Like we were talking about earlier today, I put on a collared shirt and a sport coat, and I feel like the Monopoly man, walking around all dressed up. So my 4-year-old saw me this morning and said, "What are you doing? Why are you dressed like that?"
Yeah. That's great.
But other than that, it's been, we're capable of getting everything done that we need to get done. Our clients, for the most part, are still operating. So it's, we're helping them kind of navigate this new world that we're all living in.
Yeah.
And then, we've got, at least in Ohio, our new hemp program standing up, and people are starting to get their inspections from the regulators. So, the sun still rises and sets, and we keep pushing forward.
That's awesome. Yeah, and I think we're seeing the same thing. I mean, obviously we're all working remotely, but we're seeing the same thing. Most of our clients, and again, we're helping them through it and keep working with them. So that's good. So kind of shifting the gears a little bit, one of the things that comes up in our conversations are trademarks and IP issues as they relate to the cannabis industry. Anything there that you're seeing or anything you wanted to help us out with?
Yeah, so the issue for cannabis companies when it comes to trademarks is that to get a trademark through the federal government, you have to show that your product is being used in lawful commerce. And it's awfully difficult to do for a marijuana company that is still federally illegal, right?
Right.
So you might be able to operate under state law, but it's still, banned at the federal level, which means it's very difficult to get any trademark protection. So if you wanted, if you're a dispensary or you're a marijuana processor, right, you're making infused products, you probably can't get a trademark for your infused product. So companies are left in this kind of no man's land where they're trying to figure out how to get some type of protection. And what companies are doing a couple of different things. Number one, they're looking, instead of to federal protection, they're looking to try to get protection under state law. So some type of like state trademark protection, or they're just relying on their state common law sort of trademark rights, which is fine, I guess, in your particular state, but it puts you in a scenario where you may have protection in state A, but somebody may be using that mark in state B, right? And you may not have the same type of trademark protection. Another thing that companies are doing is they're trying to trademark other types of products. So you may trademark your marijuana lifestyle brand, right? Or apparel line, in an attempt to get some type of protection for your logo, even if you can't necessarily protect it, for the actual product that you're selling, which is difficult, right? Because that means you need to actually be producing your apparel line, right? Or whatever ancillary non-marijuana product you're making, you need to show the Patent and Trademark Office that you're using that product in commerce. Otherwise, you're not going to get that trademark. And then on the hemp side, the thing that companies are running into is even though the Farm Bill legalized hemp at the federal level, the FDA has still put out guidance relating to CBD infused products. So a lot of companies are trying to trademark their CBD brands, but they need to show the U.S. Patent and Trademark Office that their products are consistent with FDA guidance when it comes to CBD products, and the FDA says you can't sell CBD products. So, you think you're out of the woods, and it's like, the old Godfather scene, right? You get away and they pull you back in. We're right back into this kind of no man's land.
Yeah. Now that's a lot of information, and it makes a lot of sense. So I'm guessing, so that's one of the impacts, obviously, about from the Farm Bill. Are there some things around law enforcement with that are issues too?
Yeah, I could talk about a couple of cases here in Ohio that we've had where law enforcement has been put in a difficult situation. So as probably everybody on this web conference knows, hemp is the cannabis plant, the same plant as marijuana, just with a different THC profile. So hemp is a cannabis plant that just has less than 0.3% THC. That looks like marijuana, smells like marijuana. So when law enforcement pulls somebody over, they're in a position where they can't tell whether that green leafy substance is marijuana, which would be illegal, or hemp, which is legal.
Wow.
And so they're having to test that product to make that determination. And a lot of state law enforcement agencies don't have the capability to differentiate yet between marijuana and hemp, because for years, they've just needed to test for the presence of THC. because any THC in a product would make it illegal. They didn't care if it was 0.3% or 25%.
Wow.
But now they need to make that determination. And so what's happening is in some states, you'll see law enforcement seize legitimate hemp product and wait to try to test it. And we've had at least 2 cases here in Ohio where people were charged with possessing marijuana, 100 pounds or something, and have gone either all the way to, a hearing in front of a judge, or in at least one case, an actual bench trial in front of a judge. And in both cases, the defendant was either acquitted or the evidence of the product was suppressed because the prosecution could not tell the judge whether it was legal hemp or whether it was illegal marijuana. And in one case that was out of Summit County, it was a bunch of product that was labeled as having 85% THC. There was no testing of the product from the defendant, but because the state bears the burden of proof, they needed to show at trial that the product was not hemp. And all they had was a lab report that said THC, yes, right? Which is insufficient to make that determination. So it has caused some issues for law enforcement when making these arrests, or from evaluating hemp shipments as they come across the applicable state.
Yeah, well, that's interesting. I mean, there's so many gray areas in that it's got to be causing a lot of headaches for companies, that whether it's hemp or marijuana, whatever it may be. That's crazy.
Yeah.
But that's good stuff. So in terms of because you kind of touched about, we were talking about hemp and obviously marijuana and the trademarks, that kind of stuff. So in terms of the cannabis derived products, which I'm sure you're kind of referring to, the CBD, CBN, and those products, regulations there are they changing? Anything positive, negative around that?
So I'll differentiate when we talk about cannabis derived products. I'm going to talk specifically about hemp derived products. And federalism is at the same time both the bane of our existence in the legal cannabis space, but at other times is our complete savior, right? We wouldn't have any marijuana industries without federalism.
Right.
But as the industry grows and develops, it becomes very difficult to deal with these patchwork regulatory frameworks that are in place, because it's all state to state to state to state. Yeah. And so, we represent a number of companies that are selling either on a wholesale basis to other businesses or are selling consumer hemp-derived products in multiple states. And you're starting to see, there are some things that are applicable in just about every state. The products have to be tested, right, to show 0.3% THC. There are some similar labeling requirements. You got to make sure you're disclosing your allergens. There's got to be some, either the COA via QR code, and COA being the certificate of analysis from the testing lab. It's generally either got to be from a QR code on the product, or the applicable test results have to be included within the package or on the label. But there are also differences. So in some states, you can't sell edible products, right? But you can sell them in other states. In some states, they don't want you to sell flower products, but in states you can. And we're starting to get to this point where not only are there disputes between each state, but then you add on the federal government on top of it that has its own sort of sets of regulations.
Of course.
And, when the 2018 Farm Bill was passed, it gave states the option to either opt into the 2018 Farm Bill, or if they were operating under the 2014 Farm Bill, right, if they already had a pilot program set up, they could remain governed by that 2014 Farm Bill program for this year. And what's happened is we've had some states opt into the 2018 Farm Bill, like Ohio, because we didn't have a pilot program.
Right.
But other states like, North Carolina or Oregon or Kentucky are continuing under their 2014 Farm Bill rules. Wow. And the issue has arisen that you have different THC testing methods under each regime, right? And that's where you end up with this Delta 9 only testing method or total THC testing method. And what I mean is, under the 2014 Farm Bill, a lot of states, when they implemented their programs, were only requiring hemp producers to test for the presence of Delta 9 THC. That was it. And as long as your Delta 9 levels were under 0.3%, it was a compliant product. You could grow it, process it, sell it, you were fine. Well, now, USDA and a number of states like Ohio have adopted total THC testing methods for purposes of determining whether a product is compliant or not. What that means is you take your Delta 9 level and you add it to 87% of the THCA cannabinoid. Because when you heat THCA, it turns into Delta 9. And it converts at about 87%. So regulators want to know, if I smoke this hemp joint, what's going to be the end result of the THC, right? Or if I heat it and make it into a product. And so you may have a product that the Delta 9 level is 0.27, but has 5% THCA. So when you do that math, it's compliant under the 2014 states,
Right.
but non-compliant under the 2018 states, like Ohio. So some states, generally on the West Coast, when they're trying to sell either their hemp flower throughout the country or infused products, they're only testing for Delta 9. But you need to test for on a total THC basis to sell it in Ohio and in some other states.
Wow.
So there are a lot of farmers that can't sell their product because it's legal in Oregon, but illegal in Ohio and in other states. So that's been one of the most difficult things to help our clients navigate.
Yeah, and that's valuable. If nothing else, I think your explanation of that was phenomenal. I mean, there's so many pieces to that, and I know that, you know, having a legal consult is major. These people, it seems like they're almost going to have legal on staff to deal with this stuff in the
I certainly
long term.
think so.
To work with you guys, it's crazy. So, Kenny, we're talking about some of the legalities, and we know that this is a regulated industry, right? We'll talk about federal in a little bit, but just at the state levels, what we find, you know, we sell. Obviously, we're providing a solution that covers the gamut of what these cannabis companies do in the cloud with a cloud solution. But we're also finding, like, dealing with Metric and BioTrack and all the different things. And obviously there are 50 states, and, you know, it's not a federally regulated thing per se, or like you talked about, it's kind of both. But, you know, how does that, you know, what do you guys talk about when you talk about dealing with Metric and BioTrack and the rules that are all there?
So for us, it's about tracking your supply chain, right? And, you know, on the marijuana side, whether it's for our medical or adult use marijuana clients, it's incredibly important from a compliance standpoint,
right?
Because the seed to sale tracking is the linchpin of the legal marijuana framework, right? The easiest way to get in trouble with your regulators is to have a problem in how you're tracking your product and a problem in your own sort of internal inventory system. And we had some of those speed bumps early on in Ohio's medical marijuana program, certainly, where whether it was your tracking system being, you know, from selling product from a cultivator to a dispensary, or inventorying products as you're selling them out of a dispensary or out of a processor entity, where the easiest way to get the ire of the regulators was to do an audit of your inventory and realize that, oh man, my system doesn't match up with state's seed to sale tracking system.
Yeah.
And so that's always the easiest way to get a problem. And then on the hemp side, it's not only compliance. I mean, we don't really see seed to sale tracking systems on the hemp side like we see on the marijuana side, but it's about quality control. And as the hemp industry matures, even, you know, it's only 6 years old, 5.5 years old from the 2014 Farm Bill. But quality control is becoming even more important. And as the industry moves from a bunch of like really small local hemp producers selling in 1 or 2 retail locations to big processing entities selling to giant CPG manufacturers and selling to these other big companies on a wholesale basis. The big guys want to know quality control. They want to know that you can track your product from the time the seed's in the ground, because they're selling at the millions of dollars level as they're incorporating things into their product. And they have those same requirements for their supply chain for any product that they're selling, right? Any spice or sugar or seasoning, whatever it is they're putting in their product, they require all of their suppliers to meet very strict requirements. And so if they're going to dip their toe into an industry like hemp that is, hyper regulated, still somewhat new and somewhat controversial, they really want to know that their suppliers have a handle on that product. And so it's incredibly important to be able to track it for your own internal purposes from the time that plant goes in the ground until you're selling the end product to the consumer. And then finally, from a liability standpoint, right? We tell our clients, congratulations, you're in a grown-up industry and you're subject to the same BS lawsuits that every other industry gets hit with, right?
Yeah.
The plaintiffs' lawyers are starting to realize that hemp producers are making money and they want a piece of it. Yeah. So you're starting to see product liability suits, consumer action lawsuits that are filed, labeling lawsuits get filed, and by and large, a lot of them relate to what's in the product. You're advertising a product as having 50 milligrams per serving of CBD. I got it tested and it's got 5 milligrams of CBD per serving, right? That's a big problem, but it's one that you can fix if you can track your supply chain and ensure that your end product has what you're telling the consumer it has.
Right. No, that's amazing, and we're seeing the same thing. So obviously, we're on the system side of the cannabis industry, and dealing with inventory and tracking. And it's interesting because from a totally different perspective, we had a similar conversation with a CPA that we had on, talking about 280E and all that kind of requirement or regular reporting and the whole metric piece. And I think that a lot of these companies have started out with that basic metric tracking or whatever it may be, but your point is well taken. Inventory, quality control, seed to sale, being able to track it, I think comes across pretty clear to everybody that that's what they need to be doing. Kind of a segue, and then I'll let you kind of like have the last word here in terms of just some general advice you have for some of the people following. We do have some people on, and but I know you've been engaged in this and active in it in terms of what might be happening at the federal level. Obviously, the pandemic and what's going on has set the whole world back a little bit. But what's coming, or what do you foresee maybe in the next few years from the federal level? Anything changing there, maybe?
So I think a lot of it depends on what happens with the election. And there was real progress that was made in the House. Towards the tail end of 2019, but that was all derailed by the impeachment inquiry. And the legislation that was making its way through the House was basically going through like the Judiciary Committee.
Right.
But that's where a lot of the impeachment investigation went through. So we got sidetracked, and now we're in an election year, in the middle of a global pandemic. I'm not terribly confident that we're going to see any movement through Congress, whether it's the Safe Banking Act, the States Act, or any other of the various pieces of legislation to address the conflict between state and federal laws. But look, if the Senate flips as a result of the election in November, if Joe Biden, the presumptive nominee for the Democrats, is elected president, and has a Democratic Congress, we could see federal change in 2021. We don't know what that will look like yet, whether it will be sort of as I said, a federalism-based approach where the feds basically take their hands off and leave it to each individual state to regulate, or whether there is some type of federal regulatory system that gets put in place.
Yeah. Yeah, I got to believe they want to tax it somehow or something. They want their piece of it. Got to come eventually. Somehow that everybody's got to get a piece of the money being made.
Right.
Like you've talked about that in a lot of different areas. I think long term it's got to be. So it'll be interesting to follow that. So I know, and we're kind of coming down to the end here with a few minutes left. Just in general, for the audience, just some advice you have around whether they're just getting started or they're heavy into it, or when this is over and they're really all at it, which I think most of these companies have kept in business and keep moving. Anything you wanted to just put out there for them to think about or keep on the plate?
Yeah, one of the first things I always tell my clients, I take a compliance first approach with all of my clients. It's easier to make money if you have your license than if you're fighting with your regulator and at risk of losing it, right?
Right.
And so for me, you really need to pay attention to the states that you're operating in because each state can be different. They each have their own individual nuances, whether it's in the marijuana side of things where it's very clear that certain things need to be licensed by the state. Everything's very controlled within a state's particular borders. Or whether it's in the hemp industry where you're selling product across state lines. Sometimes folks don't consider that the rules in Ohio might be different than the rules in Pennsylvania. And conduct in one state that doesn't require a license may require a license in another state. And the easiest way to have an adverse impact on your business is to not pay attention to all of those rules. So that's the first thing we always say to our clients. You got to protect yourself, right? You got to build the foundation of your business just like you build the foundation of your house. If you're on shaky ground from a compliance or even corporate governance standpoint, that will eventually affect your business down the road.
Yeah, no doubt about it. And we agree. I mean, that's from cradle to grave. They need to be thinking about it. And I know that's been helpful. So I really appreciate, I know we do appreciate your coming on with us. I know it was a half hour. It seems like we crammed a lot of great information into 30 minutes. There's quite a bit to learn. And we'll make sure that anybody that's joined it knows how to contact you if they need to. And we look forward working with you because it helps us a lot understand the legalities and what we're working with when we're out talking to our prospects. So I hope you stay safe and maybe eventually we'll actually be able to be face to face in front of a real scene, right? And we'll be able to talk again. I think that's coming pretty soon too. So anyway, Tom, I really appreciate your time and wish you nothing but good health, and we'll be talking soon.
Thank you, Frank. Great. Same to you and your family. Take care.
Thank you. Appreciate that. And for everybody joining on the screen, you'll see we do have some more upcoming chats or series coming along. Thursday, we'll be talking about how consumers have changed their buying and specifically some issues around sales tax and that type of thing, which we know, again, it's either tax or law seems to be the hot topics and everything we talk about these days. So, and a couple other things coming up as well. So feel free to join us, and we look forward to talking to you on Thursday. Thanks, Tom. Appreciate it.
Thank you, Frank.
Bye.